the Madras High Court. It was carried before the Supreme Court in a constitution bench judgment. And in the celebrated judgment of Champakaran versus the state of Madras, the Supreme Court upheld the judgment of the Madras High Court and held the provision of reservation to be unconstitutional. And therefore we find that in the very first amendment in 1951, the amendment which was moved by none else than Pandit Jawaharlal Nehru, Article 15 was amended so as to provide for reservation for the backward classes. Similarly, between 1946 to 1950, various states, in order to provide for agrarian reforms like the Ceilings Act, like the Agricultural Tenancy Acts, had enacted various laws. Those laws were challenged. Some of the high courts upheld the validity of the laws. Some of the high courts negated the validity of the said enactments. And therefore, in order to bring about clarity, the same amendment also inserted Article 31A and 31B so as to provide for the agrarian reforms. The issue with regard to amendment of the Constitution came to be considered by the Supreme Court as early as in Shankari Prasad, to which the learned Chief Justice has referred to. And by a unanimous verdict, the 5 judges held that the Parliament's power to amend the Constitution cannot be restrained. It was held that if the Parliament, in order to answer the socio-economic challenges faced by the subsequent generations, is restricted for amending the Constitution, then the Constitution would not be a static or would not be a living document, and it will be a static document. That was subsequently considered in suggesting by virtue of 3-2, the power of the Constitution, power of the Parliament to amend the Constitution came to be upheld. But the seats of dissent were sowed in the very same judgment. Justice Hidayatullah said that to hold that the Parliament's power to amend the Constitution are unbridled, and they can even amend the Constitution to take away the fundamental rights, I would require stronger reasons than the ones given in Shankari Prasad. Justice Mudolkar, he said that if the power to amend the Constitution is to be construed as taking away the basic features of the Constitution, then the word amend will have no importance and it will amount to changing the Constitution. And therefore we find that the concept of basic structure as evolved in Keshavanand Bharati has its roots in the case of Sajjan Singh. Subsequently, the 9 judges in Golaknath held that the powers of the Parliament to amend the Constitution were restricted and it could not amend the Constitution in a manner it takes away the fundamental rights of the citizens. That gave rise to the 24th, 25th and 26th Amendment, by which various articles were either inserted or amended so as to carry forward the goal of the Indian Constitution of achieving social and economic justice. The same came to be challenged in the Keshavanand Bharati, wherein the Supreme Court, for the first and so far for the last time, sat in a combination of 13 judges. Insofar as the power to amend the Constitution is concerned,